I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator Durbin, Ranking Member.
It's been a long time since I took a bar exam, and I remember getting the envelope and said with good news that I had been accepted, and I breathed a sigh of relief to think I'd never have to face another test. Well, you've just gone through the Senator Kennedy bar exam. It's been a tough one for a lot of nominees, and lucky for us, he doesn't ask his colleagues these questions, only the nominees. So I wish you well, and I acknowledge you asked some tough questions, Senator. Judge Pratt, just a few weeks ago, you...
It's only a position for life, Mr.
Understood.
Mr. Chairman.
Judge Pratt, a few weeks ago, you wrote an opinion in which you held that a Florida law allowing minors seeking abortions without parental consent, but with judicial waiver, was unconstitutional. The case involved an appeal from the trial court's denial of a 17-year-old's application to obtain a judicial waiver of the parental notification and consent requirements for an abortion. Under Florida law, judicial waivers in this context have been permitted. However, your decision held that Florida's judicial waiver procedures were unconstitutional and violated the parent's due process right. This wasn't something you wrote in an op-ed piece, nor was it a case you argued zealously on behalf of a client. This was last month, and you wrote this opinion as a state court judge. In commenting on your opinion, one lawyer said, judicial override doesn't even begin to describe what this judge did. There are also serious concerns with your decision's potential impact on victims of incest or abuse. So, should a minor who is sexually assaulted in your state be forced to give birth if her parents do not consent to her having an abortion?
What's up, Patriots? Welcome back to America First. I'm your host, and if you're new here, make sure you hit that like button and subscribe, because we're bringing you the real conservative commentary that the mainstream media won't give you. Ring that notification bell so you never miss our latest content defending our constitutional values. Today, we're diving into some absolutely crucial footage from a recent Senate Judiciary hearing that every American needs to see. This is about Judge Pratt, who's up for confirmation to a lifetime position on the federal bench. And folks, what you're about to hear should concern every parent and every person who believes in constitutional government.
Senator, my opinion on behalf of our court expressly made clear that that was not a situation that was presented in the case. The case concerned a waiver request on the basis that the minor asserted that it would be in her best interest not to include her parents, not to allow her parents to be notified of her contemplated procedure. And as the opinion, explains, I think I don't want to go behind the face of the opinion, but I'm happy to explain the opinion. The opinion holds that the parents have, at a minimum, a due process right to notice an opportunity to be heard, and this is presumptively fit parents, have a right to notice an opportunity to be heard if the state seeks to abridge or to remove their right to be involved in the medical decisions of their children. So that is the basis of the opinion.
I think you went further than that, as I understand it. Your decision held that Florida's judicial waiver procedures were unconstitutional and violated the parents' due process rights. Unconstitutional under the I don't know the Florida Constitution, obviously, but your argument was that it was unconstitutional under state constitution or federal.
So, Senator, it wasn't my argument, but the reasoning of the opinion that I authored on behalf of the court is that the due process clause of the 14th Amendment to the United States Constitution requires, as with any other circumstance when someone's substantial rights are at issue, notice and opportunity to be heard, essentially a opportunity to provide an explanation to the court why the court should or should not take the contemplated action. And there's a body of precedent that the opinion cites regarding the fundamental requisites of the due process clause being notice and opportunity to be heard.
Different states have different laws, and certainly the judicial waiver is put in place so that when there's a question of parental consent, there's an option for the victim to petition the court for permission to apply the waiver. And as I understand it, you found that petition to apply the waiver unconstitutional. That's the way I read this. Let me ask each of you, we've had a recurring question here about the impact of a court order. How seriously should a party to a conflict take a court order? Judge Orta?
Very seriously.
And do I have the right, if I'm in your court, or any court for that matter, and a decision is reached, to say that I just don't agree with it, I don't have to live by it, or am I bound by that order until I've exhausted rights of appeal, for example?
Well, Senator, there are stays that can be pursued. Of course, there's appeals that can be exhausted that may be able to be exhausted. You may be able to post a bond to exhaust such things. You may be able to move for rehearing on it. There may be some exceptions, but for the most part, court orders are court orders.
Well, and I think you just heard, you sat through several hours of questioning on a potential nominee for the circuit court as to whether or not he was following the court order, oral or written, I'm not sure, when it came to launching a plane with detainees in it to another country. So this is a serious question which is going to recur frequently here, I'm afraid, under this administration. I yield at this point.
Thank you, Ranking Member. Senator Whitehouse, do you want to go ahead and?
Let me break down what happened here, because this is a perfect example of judicial activism run amok. Judge Pratt recently wrote an opinion striking down Florida's parental consent laws for minors seeking abortions. Now think about this for a second. We're talking about a 17-year-old child who wants to have a major medical procedure without her parents even knowing about it. And this judge thinks that's perfectly fine. Here's what really gets me fired up about this case. Florida had a reasonable law that said if a minor wanted an abortion, the parents need to be notified and give consent. But the law also included a judicial waiver process for exceptional circumstances. This is actually a balanced approach that protects both parental rights and addresses genuine emergency situations. But Judge Pratt decided that even this balanced approach was unconstitutional. The judge's reasoning here is completely backwards. Pratt argued that parents have a due process right to be notified when their minor child is seeking an abortion. On the surface, that sounds reasonable, but here's the problem. The judge used this reasoning to strike down the entire judicial waiver system. This means that even in cases where parental involvement might not be in the child's best interest, there's no alternative pathway. What's really troubling is how this impacts parental rights, which are fundamental to conservative values. As parents, we have not just a right, but the responsibility to be involved in our children's medical decisions. The idea that a minor can undergo a serious medical procedure without parental knowledge flies in the face of everything we believe about family values and parental authority. But here's where it gets even more concerning. During the hearing, senators raised legitimate questions about how this ruling affects victims of abuse or incest. Judge Pratt's response was essentially that those situations weren't part of the specific case, so the ruling didn't address them. This is exactly the kind of narrow, technical legal thinking that ignores real-world consequences. Think about what this means practically. A teenage girl who is being abused at home now has no legal pathway to seek help through the court system if she needs an abortion. The judge eliminated that safety valve entirely. This isn't conservative jurisprudence. This is ideological activism that puts legal theory ahead of protecting vulnerable young people. Now, I want to be clear about something. As conservatives, we believe in the sanctity of life and we oppose abortion. But we also believe in the rule of law and proper constitutional interpretation. What Judge Pratt did here wasn't conservative legal reasoning. It was judicial overreach that created a rigid system with no flexibility for extraordinary circumstances. The other issue that came up in this hearing was about respecting court orders. Senator Durbin asked about how seriously parties should take court orders, and this is actually a crucial question for our constitutional system. Judge Pratt gave the right answer here, emphasizing that court orders must be followed even if you disagree with them, with proper appeals processes being the way to challenge decisions. This is important because we've seen too many cases recently where people think they can just ignore court orders they don't like. That's not how our legal system works. Whether it's immigration cases, election disputes, or any other legal matter, court orders have to be respected while you pursue proper legal remedies. What really concerns me about Judge Pratt's nomination is that this represents a pattern we're seeing with this administration's judicial picks. They're choosing judges who engage in activist interpretations of the law rather than strict constitutional interpretation. This isn't about conservative versus liberal politics. It's about whether judges will follow the law as written or try to make policy from the bench. The abortion issue here is just the tip of the iceberg. If Judge Pratt is willing to strike down reasonable state laws that protect parental rights, what other constitutional principles might be at risk? Property rights? Religious freedom? The Second Amendment? When judges start making decisions based on their personal policy preferences rather than constitutional text and precedent, every constitutional right becomes vulnerable. This is why these confirmation hearings matter so much. Federal judges serve for life, and their decisions shape American law for generations. We can't afford to put activists on the bench who will use their positions to advance political agendas rather than faithfully interpret the Constitution. The questioning from Senator Kennedy that was referenced in this hearing shows exactly the kind of scrutiny these nominees need to face. We need senators who will ask tough questions about judicial philosophy and past decisions. The American people deserve to know exactly what kind of judge they're getting before these lifetime appointments are confirmed. Here's what every patriot watching this needs to understand. This isn't just about one judge or one case. This is about the fundamental principle of constitutional government. Do we want judges who will interpret the law as written, or do we want judges who think they know better than the people and their elected representatives? The founders designed our system with separation of powers for a reason. Congress makes the laws, the executive enforces them, and the judiciary interprets them. When judges start making policy instead of interpreting law, they're undermining the entire constitutional framework that protects our freedoms. This is exactly why we need to stay engaged in these confirmation fights. Every single judicial appointment matters, from the Supreme Court down to district judges. These are the people who will be deciding cases that affect our lives, our families, and our constitutional rights for decades to come. Patriots, this is why your voice matters. Contact your senators and make sure they understand that you expect them to thoroughly vet these nominees. Don't let them rubber stamp activist judges who will use their positions to advance liberal policy agendas. We need judges who will uphold the Constitution as written, not as they wish it were. The stakes couldn't be higher. Our constitutional republic depends on having judges who understand their proper role in our system of government. Judge Pratt's decision in this Florida case shows a troubling willingness to second-guess reasonable state laws and eliminate balanced approaches to difficult issues. This is America first, and we're going to keep bringing you the truth about what's happening in Washington. Make sure you're subscribed because we've got more coverage of these confirmation hearings coming up. Like this video if you found it informative, and share it with other patriots who need to understand what's at stake. Remember, the price of freedom is eternal vigilance. We can't afford to let our guard down when it comes to protecting our constitutional rights. Thanks for watching, and I'll see you in the next video.